Welcome to Constangy Clips, the series with tips on staying ahead of important legal challenges in the workplace and cyberspace. My name is Kristin Titley, and I'm an attorney in Constangy's Nashville office. Today, I'm going to walk through 5 common questions employers ask about the Americans with Disabilities Act and the Family and Medical Leave Act. The ADA and the FMLA are 2 of the most important workplace laws, but they are also 2 of the most frequently misunderstood. Employers often think of them as completely separate, when in reality, they often overlap. That confusion can lead to compliance mistakes and unnecessary legal risk. Here are some of the questions that come up most often. What are the key differences between the ADA and the FMLA? At a high level, the FMLA is a leave law. It gives eligible employees unpaid job-protected leave for certain qualifying reasons, many of which have nothing to do with an employee's disability. By contrast, the ADA is an anti-discrimination law that may require employers to provide reasonable accommodations to qualified employees with disabilities, though it also has some provisions that apply to all employees, even those without disabilities. Sometimes ADA accommodations may include leave, but leave is not necessarily the only option. The FMLA also has relatively strict eligibility requirements, and leave related to the employee's own medical condition is available for only 12 weeks per year. The ADA reasonable accommodation requirement, on the other hand, can continue throughout the duration of the employee's employment. These distinctions matter. The FMLA is about protected leave for a variety of reasons. The ADA is about non-discrimination and accommodation for employees with disabilities. And in many situations, employers may need to think about both. What happens when an employee has no FMLA leave but still cannot return to work? This is one of the biggest trouble spots for employers. The fact that an employee is not eligible for FMLA leave, or that the employee has used up his or her available leave, does not necessarily mean the employer's obligations are over. If the employee's medical condition is a disability within the meaning of the ADA, the employer should pause and consider whether the employee may be entitled to a reasonable accommodation under the ADA, even if FMLA leave is not an option. That means automatic termination at the end of the 12 weeks of FMLA leave can create real legal risk. Under the ADA, providing additional leave may be a type of reasonable accommodation. There also may be other accommodations that would help the employee return to work. Does an employee have to specifically ask for FMLA leave? No. Employees do not have to say FMLA to trigger potential protections. They only need to provide enough information to suggest that the absence might qualify. Employers who wait for magic words can miss their obligations. If an employee mentions a surgery, a serious medical condition, ongoing medical treatment, or the need for time off to care for a family member, that may be enough to put the employer on notice. The employer should recognize the issue and follow up, rather than waiting for the employee to make a perfectly worded request. It is equally important that managers and supervisors understand this and know where to direct an employee who raises one of these issues, whether that is HR, leave administration, or another appropriate internal contact. Does an employer have to provide the exact accommodation the employee asks for? Not necessarily. Under the ADA, the employer must provide a reasonable and effective accommodation that permits the employee to perform the essential functions of their job. But the employer does not have to provide the employee's preferred accommodation if another effective option exists. As long as the accommodation is effective, the employer can provide a less expensive or less disruptive accommodation. That said, employers should be careful not to shut the conversation down too quickly. A common mistake is treating the employee's initial request as something that must either be accepted or denied on the spot. That is not the process. The real question is whether there is an effective accommodation that addresses the employee's limitation. Again, though, if there is more than one effective option, the employer can usually choose from among them. What exactly is the interactive process under the ADA? The interactive process is the back and forth discussion between the employer and the employee about the employee's limitations and possible accommodations. It is supposed to be a good faith conversation, not a one-sided decision. If the employer can easily grant the accommodation requested by the employee and is willing to do it, then it can grant the accommodation without engaging in the back and forth with the employee. But in many cases, it's not that simple. In all other situations, a proper process usually includes understanding the employee's restrictions, discussing possible options, possibly consulting with the employee's healthcare provider, evaluating whether the options are effective, and documenting the steps taken. The goal is collaboration. Employers do not have to guess, and employees do not have to navigate the issue alone. But the employer does need to participate in the process thoughtfully and consistently. Ideally, this back and forth will take place via in-person conversations between the employer and the employee. But video conference, phone calls, and emails are also fine. So to wrap up, the ADA and FMLA can be complex, but many compliance problems come down to a few recurring misunderstandings. Employers should avoid rigid rules and instead evaluate each situation carefully, taking the time to follow the right process, consider overlapping obligations, and document decisions can go a long way toward minimizing risk. And when in doubt, consult employment counsel to make sure these issues are being handled correctly. Thank you for watching. Be sure to follow Constangy on LinkedIn, Facebook, and YouTube for important updates and more tips for minimizing risk in this dynamic legal space.